Starting at the top of page 4, once again, don't forget to write the date in right there. The first paragraph is dealing with the condition of the property. All properties are sold in their present physical as-is condition as of the date of acceptance, but they are subject to buyer's investigation rights. The seller must disclose to the buyer if there has been any insurance claims within the past 5 years. And the buyer has the right to inspect the property, and based upon what he's discovered in those inspections, he can actually cancel the agreement. He does not have to request the seller to repair anything. He can merely cancel if he's not satisfied with his inspection. Or the other option is that he can negotiate with the seller to make some repairs, or perhaps give him a monetary credit so he can hire his own repairman to take care of any issues. And the reason why the buyer is strongly advised to conduct an investigation is because the seller does not always know or is aware of the defects that he may have in his property. Maybe he never went into his attic. Maybe there's areas that he hasn't really seen. Maybe there's changes to the property that the prior homeowner did and they were not done according to code, or they were not done with permits. So if this is an issue with your buyer, this is something that he has the right to investigate. So this offer is contingent upon the condition of the property, and the buyer at his expense can have any investigation he wants. And home inspections are usually required to be paid on the spot, so you can make sure your buyer is aware of that. If there's any invasive type inspections that the buyer may want to do, because I've seen some cases where there look like there might be black mold, and a buyer needed to break into the drywall to really see how extensive that mold problem is, he has to get permission from the seller to do this kind of destructive investigation. And he has to also protect the seller by making sure that his inspector has the proper insurances to cover himself in case anyone gets injured or in case there's extensive damage to the property. The buyer is also obligated to give to the seller at no cost to the seller complete copies of all his investigative reports. The seller is obligated to have all the utilities turned on so a proper investigation can be conducted, clear through the date of possession of this property. And the buyer, like we said, shall require anyone acting on his behalf to carry policies of liability, workers' compensation, and so forth to protect the seller. Paragraph 11 is talking about other disclosures that you may want included and provided by the seller. This is not saying you're going to attach them and you're going to include them. No, it says the seller shall provide these items. And I checked on the typical ones that you would want in a standard sale. Title investing will be determined through escrow. You should always have your client get advice from legal counsel to see what is best for them, the way to carry title. And at close of escrow, they'll be given the grant deed and the type of prelim or title that they will have. Homeowners title insurance is a CLTA, ALTA, homeowners policy of title insurance. This is the best type of policy that they can get, so you should make sure that this is the type that's ordered. Banks do not order this type of policy, even though it's in the purchase agreement, and this is the type you want. If the buyer has to sell a property, buy a property, this is where you would check this box and attach the appropriate form, contingent upon sale of buyer's property. So that's the end of page 4.